Will my kids have to pay taxes if I put my home into a revocable living trust? Well, it's a question I receive from many of my clients who are considering setting up a trust, and in today's video, I'm going to answer it. Hi, my name is Chuck Roulet. I'm an estate and elder law attorney licensed to practice law in both Florida and Minnesota. Now, most of my clients tell me the reason they are doing estate planning is that they want to make it as easy and inexpensive as possible for their family to take care of everything after they pass away. Well, we all want to make things as easy as possible for our loved ones when we're gone. But unfortunately, failing to do basic estate planning can cause, huge messes and unnecessary costs for your family after you pass away. So for example, just look at what happens if you own your home in your individual name and you don't have a trust or an estate plan in place. So absent planning ahead of time, your family does not have the legal authority to sign the paperwork required to sell your home and manage your assets. So upon your death, your home has to go through the probate process before it can legally be distributed to your kids or other heirs. And probate is a lengthy, public, and extremely expensive court procedure. So for example, depending on what state you're in, the average probate timeline can be anywhere from 6 to 18 months, but can actually take years if there's a contest or something happens. All records, filings, and proceedings are open to public record. Okay. Now, total costs can eat up anywhere from 3 to 8% of the estate value in court costs and attorney's fees as part of going through the probate process. And if estate taxes exceed, if the total value of your estate exceeds certain value, then estate taxes kick in, and your kids may owe heavy taxes just for inheriting. So your family is at the mercy of the court schedule with zero control. It creates a huge hassle, expense, and delays for your loved ones at one of the most difficult times while they're dealing with the passing of a family member. But here's the good news. All of those probate nightmares and estate taxes can easily be avoided by utilizing a revocable living trust as part of your estate plan. So a trust is a legal entity you create, and once you create it, you transfer your home and other assets into it. You maintain full control over everything while you're alive. Okay, you're the trustee. You can open your trust, put things in, take things out. You can change the terms of the trust. After you pass, though, whoever you have named as your successor trustee or trustees, you can name more than one, and often it's one or more of your adult children. They step in and then distribute the assets in the trust per the instructions you've left for them in the trust instrument. All of this happens privately and outside of the probate court system. So instead of that lengthy, expensive public court process, your trustee can quickly, efficiently, and privately transfer your home and assets to your heirs according to your exact wishes as laid out in your trust. Now, just as important, a properly structured trust can allow you to minimize or even eliminate estate taxes, helping you to preserve your wealth for your family. So the federal estate tax rate is currently 18 to 40% for estates above the exemption amount. And while the exemption is high at the time of this video, it's set to sunset in 2026 and impact many more families. So again, the way that works is total up the total value of your estates. We add in the value of your home, your retirement accounts, your life insurance, your investment accounts. If the total value of the estate is below the exemption amount, not subject to the estate tax. But if you tip over it, you are. And again, that number is set to be substantially lower at the federal level in 2026. Also, many states have their own estate and inheritance taxes, such as Minnesota. So again, it's really easy for a lot of couples in particular, once they add up the value of their home, their investments, their life insurance, and retirement accounts, for the total value to exceed either or both a state tax exemption or potentially the federal exemption, again, particularly if it sunsets in 2026. And that can result in massive estate tax bills for your family just for inheriting your assets. Now, having said that, by utilizing an AB trust, what's called an AB trust for married couples, along with other advanced strategies, you can double or maximize your exemptions and defer taxes until after both of you are gone, and may even completely avoid taxes. This helps to protect your assets from being eroded by taxes before passing to your kids. Now, also, regardless of whether or not you use a trust, under current law, your children or other heirs receive what's called a full stepped-up basis on any inherited assets, including the home. And the stepped-up basis is the property's fair market value on the date you pass away. Now, this is a major tax advantage over receiving property as a gift during your lifetime. So with an inherited home, Capital gains taxes only apply if when your heirs sell the property for more than the stepped-up basis value versus being taxed on the lower original cost basis from decades ago. So here's how this would work as an illustration. So let's assume, for example, you purchased your home 40 years ago and you paid $100,000 for it, and it's worth $800,000 when you die and leave it to your kids. They inherit it at the $800,000 stepped-up basis. They can then turn around and sell it for $800,000 with no capital gains taxes versus potentially owing tax on $700,000 of gain, the difference in what you paid for at your basis versus the fair market value at the date of death, if you had given it to them while you are alive. So again, it's important to note that capital gains taxes may still apply, though, if your heirs don't sell the home in a timely manner after inheriting it and the value continues to appreciate before they sell. But the takeaway here is if you gift it to them while you're alive, they're going to take your basis and they're going to have to pay capital gains. If you put it into a revocable trust, it's the same way as if they inherited otherwise. Under current law, get basis step up, no capital gains tax. Now, in addition to probate avoidance and helping to maximize tax savings, putting your home in a properly designed trust can also provide valuable asset protection for your heirs' inheritance. So if you leave assets outright to your kids through a will, it's potentially exposed to their future creditors, lawsuits, divorces, bankruptcies, etc. However, assets inherited through a properly designed trust can actually be shielded and insulated from your beneficiaries' outside claims. Now, they still get to benefit from the assets, but their inheritance is protected from being seized or squandered. This helps to ensure your home and other hard-earned wealth actually makes it to your children and grandchildren rather than being lost to creditors or divorces down the road. Now, it's important to note that most revocable trusts do not include these asset protection provisions in them. However, it's something we can include when working with our private clients. Now, what's more, having assets owned inside a revocable trust provides much easier, streamlined management both during your life and after you've gone. As the trust maker, the one creating the trust, you maintain full control while living to make any updates needed. If you become incapacitated, your named successor trustee or trustees can take over seamlessly without court involvement. And after you pass, your trustee has customized control to facilitate the most tax-efficient distribution to each heir, whether that's deferring distributions, creating streams of income, or even holding assets in further trust for spendthrift beneficiaries. The bottom line is putting your home and assets into a revocable living trust provides invaluable benefits and advantages you can never achieve by simply owning property in your individual name or basic will. Again, to recap, it avoids probate court hassles, fees, and delays. The trust can be designed to minimize or even completely avoid estate taxes for substantial savings for you, protects your kids' and grandkids' inheritance from their creditors, unified management when needed, customized control over asset distribution, straightforward, effortless inheritance for heirs. So again, not only do you avoid the probate process, but the trust can actually be designed to actually minimize and help save on taxes. Now, if you would like more information, I'm hosting a free online masterclass, and you can sign up by clicking the link below. And in this class, I'm going to reveal insider strategies for your will, your trust, your powers of attorney, your healthcare documents that can help your family avoid probate, save on taxes, and make it as easy and inexpensive as possible if something were to happen to you. And if you haven't already, make sure you hit the like, subscribe, and bell notification so you'll be alerted when I upload additional videos. Finally, if you have a question, post it in the comments below and I may answer it in an upcoming video. Having a well-crafted trust in place can help make it as easy and inexpensive as possible for your family to manage your affairs if something were to happen to you. It can help minimize or avoid taxes and protect what you are leaving behind for your children and grandchildren. I hope you found this video helpful. I look forward to seeing you in either the next video or in the masterclass. Be well.